Welcome to Badass Breakthrough. My name is Bridget Bennett. I am your host. I am a high conflict custody and divorce coach, fellow survivor of domestic abuse, and I am here to help you on your way. This show is for those who have found their way navigating co-parenting with a high conflict or narcissistic person, battling it out in family court, feeling like that journey is never going to end, maybe discovering that they are a product of a narcissistic family, and overall for those that are trying to rebuild their life after enduring abuse, whether it was through a relationship or marriage. You're in the right place. This show is for you. So let's get started on this journey together. Good morning. Welcome back. I'm really glad that you were here today. And because I want to talk to you about something that I think most people end up asking me. And I think that this topic actually causes more panic and often like bad decisions in cases, um, just like unnecessary type of suffering, more than any other topic that I tend to discuss, right? And I I want to dive into the life of a custody case, right? And like what that looks like so that we all have a better understanding. Most people absolutely have like no idea how a custody case works from start to finish, right? So they need to have a deeper understanding, right? I think anybody needs to have a deeper understanding of the different stages of each case, understanding what the stage means or what your job inside that stage of your case actually is at that time. Okay. Are there things that you should be preparing and doing? Or can you just sit back and wait for your attorney to help you? Right? Has the work already been done at that stage in your case? I find that people often make like desperate moves at the wrong times and they give up at the wrong time. But I think that largely it boils down to a lack of knowledge and education about the court system, just kind of overall, right? So today I want us to walk through the full life cycle of a custody case, right? So from the very beginning all the way through final orders and beyond, right? What happens after a final order? Here's the thing that I really want you to hear during our conversation. A final order is not the finish line. It never has been. And understanding that like changes just our whole dynamic, right? It changes our approach and it also can help us improve our process. So whether you are starting out and you have no idea what is coming next, you might be in the middle of your custody battle right now. You might have temporary orders and you're wondering what comes after this. If you have a final order and it didn't go the way that you wanted it to, you think it's over, I want you to stick with me today because this conversation is for you. So let's talk about the very beginning of a custody case, right? Like every case starts with a filing, right? So this is the filing of a complaint, an initial petition. It's the filing that starts it. You either file something or your ex files something, but someone initiates the process. And I want to address this because I hear it often. You guys ask me these questions. Does it matter if they filed first? What does it mean? Am I already behind? If your ex files before you do, it doesn't mean that you're behind. Who is the filing party doesn't determine who wins. It determines who sets like the initial narrative of the whole case, right? So the moving party, the filing party, is the party that tends to get their story out there first. And then you often file a reply, right? So, what is your job from the moment that that filing happens? Well, it's to start building the counter narrative with your documentation, with your own behavior, right? My ex says that I'm crazy in this filing. My ex says that I am the abuser, right? That I'm abusive to them and to therefore the children. Okay. You know that that's not true. What evidence can we gather? How can we behave differently so that it counteracts their argument? After the initial filing in court, right? Typically, what happens is you're called into maybe like a status conference or mediation. I want you, and this can also be like an initial hearing, right? The judge will order you to a status conference or to mediate. Mediation is also not the end of the world, right? Are you likely going to reach an agreement with your ex? Probably not. Not in mediation, but it's a great learning opportunity. It is an opportunity for you to see their cards, for you to see exactly what it is that they're asking for and what they are pushing as their narrative. Okay. It gives you information. This is really essential, like the first steps in getting your case organized, right? The judge tries to later figure out issues that are contested. So, I have clients that go through the mediation process and maybe they're able to agree on certain things. Then there's other items and aspects that are not agreed to. What happens with that? So we can, and we've seen this, right? There's maybe a consent order that is put in where the parties have agreed to A through Z things, right? But then we have parts 1 through 10 that haven't been agreed to, right? The things that are not agreed to then go forward to a judge for a decision. I want you to understand that mediation, even like status conferences, it's the court's way of saying, all right, you two need to try to go figure this out first before I make a decision. And they're also wanting to learn about the case. They're wanting to understand what it is that they're dealing with. We often, right, from maybe the initial hearing, maybe even prior to the mediation, we get in these temporary orders. Okay, so temporary orders. This is a stage that I think is deeply misunderstood and it causes a lot of like panic. Temporary orders are put in place to create stability for the child while the case is working its way through the system. Okay. So they cover things like custody schedule in the temporary order, decision making. Sometimes child support might be covered. Who is going to be the primary parent? Where is the child primarily going to be residing? Are there any communication requirements? What's the vacation schedule? The temporary orders are meant to be like it's a holding pattern while everything gets sorted out. Okay. Now, here's something I want you to understand temp orders feel permanent, but they're not. Okay. It's a starting point. I want you to write down if you are somewhere that you can do that. This is the starting point. This is not the finish line. Okay. Starting point, not finish line. Here's the other thing that's also true. And this is where some people make a big mistake. Temporary orders matter more than most people realize. Okay. And judges are human beings. Yes, there's a lot of real corrupt judges. There's some great pages that I have found more recently on Instagram where they're exposing, right, those bad family court players such as judges, gals, etc. Anyways, the arrangement that has been in place and how it's been working tends to feel familiar and safe to judges. Okay. So when we have temporary orders, there's a schedule that's initially put out for the child with both parents. Now, what happens from temporary orders, and this is where people get it wrong, I don't often see drastic changes from temporary orders to permanent orders. Okay. The reason for this is that judges often stick to the status quo, right? So they would then be disrupting a temporary arrangement that potentially appears to be stable, at least to them, And if they're wanting to disrupt it, they need to have a really good reason as to why, right? It requires evidence. And we're not going to say you're trying to prove that your ex is abusive or that your ex is terrible, but we have to turn that to show how this schedule right now in place is not in the child's best interest. Everything that you're doing during the temporary period, you're building something either towards your case or against your case. This is not the time to check out during temporary orders, right? Is your ex following the temporary orders as written? Probably not. What is not working well? What has been working? I want you to keep track of both of those things. Document the violations, right? But we're also documenting the successes. Remember what I say. We want to bring both things, what isn't working as well as what is, because it helps to make you look like the reasonable parent. This is your opportunity to show the court who you are and how you're showing up as a co parent. All right, so what happens after temporary orders are in place? Cases start moving. We often see cases move into the discovery phase. Now, discovery is a formal process where both sides are exchanging information. And I know the word like itself can sound pretty intimidating: interrogatories, requests for production of documents, requests for admissions, right? But discovery, I want you to see it differently. This is actually an opportunity. Okay. You're going to receive written questions that you're going to have to answer under oath. You don't have to give them all of the information. Okay. This is not the time. This is now actually a great opportunity for you to get into the practice of like, okay, I don't need to say every bit of the story. Sometimes less is more. Okay. During the discovery process, when we have requests for production of documents, there's often a lot of requests for like financial records. If your ex is trying to spin the narrative that you're crazy, mental health records, medical records, school records, these can also be subpoenaed. Okay. Some cases I've seen where depositions are taking place of the parties. Um, for me personally, I think that depositions can be avoided if discovery has been served. And also, attorneys serve discovery in family law cases and go through depositions often at the very beginning of cases. It's a way of getting billable hours too. Okay. But I do find that discovery is more helpful than a deposition. We look at discovery as a learning opportunity. We're going to see what information are they giving me back, right? So if your ex's attorney has served you discovery, then your attorney, or if you're representing yourself, you should also come up with your own set of questions, your own discovery. If you're pro se, this is great for you to implement AI as a tool. You want to make sure that it's following the local rules, the state rules, and guidelines in terms of discovery. There are limits to how many questions you can ask, so make sure that you pay attention to what those are. Look it up. High conflict people lie compulsively, and they tend to create contradictions in discovery, in the discovery process. And I think that those contradictions, again, are very helpful for you to use later on. So take the discovery stage seriously. Make sure that your attorney is responding timely or that you're responding timely. And if not, you need to request an extension of time. Mediation, I've touched on this, okay, as a learning opportunity. But mediation will still happen before a hearing. And you're like, I don't know what the point is. We never agreed anything yet. Remember, you are getting information. The court wants to see that you guys are trying to settle the case before taking up their trial time. Now, it depends on where you are, right? some states and countries and jurisdictions, like for example, North Carolina, I can speak of that well because that's where I lived. That's where my case was. The mediator does not present a report. The mediator does not give a recommendation to the judge. That's the point of mediation, is for the parties to, have a conversation that is not going to later be used as evidence in a case, because it provides this environment of, freely going back and forth and like trust and confidence. Now, in some states, like the state of Washington, state of California, even, I've seen where mediators are making written recommendations to a judge. Okay. I don't find that that's helpful, but again, that is the process in some areas. Mediation, I want you to know, it's not a therapy session. This is not a place for you to vent to the mediator of how terrible your ex is. Okay. It is a place to, process what's happening for your child, for, you to present a parenting plan, a recommended schedule, and why you feel that that would work best for your child. The mediator's job is to be neutral. They're not your advocate. They're not your advocate. They're not the kid's advocate. They are not there really to protect you. The job is for them to facilitate an agreement so that the case settles and does not take up the court's time. In high conflict situations, mediation is often used by, the abusive party as another opportunity to, try to manipulate, pressure you, wear you down. They get the sense that you want it to be over. They know you are exhausted. This is why we see ongoing litigation over and over again. We see repeated filings over and over again. Okay? Before you walk into mediation, having some notes prepared of what it is that you're really wanting. Okay? What are your bottom lines? And what are things that you're willing to compromise on? Okay? You can compromise on things. Do research in your area on the judge that you have, on other cases that have been heard. What is the likelihood of the judge ordering what you're asking for? Okay, again, remember what I said at the very beginning. Temporary orders, and even if we get a final order, it's not a final order. You can always go back and modify. Okay, this is a great opportunity for us to learn to let go of some shit and to give our ex rope. Okay, you want to be Disneyland daddy? Here you go. If mediation fails, the case goes straight to a hearing. Again, there might be parts that you guys are able to agree on that can go into a consent order, and the other parts that are not agreed to would go before a judge to be heard. I don't want you to feel forced that you have to settle for a bad agreement just to avoid going to hearing. Now, this is something that high conflict people know, that you're likely not in a financial spot to pay for ongoing litigation, right? Because they're financially abusing you. They know this. It is done by design. But just because of that, I don't want you to feel pressured to settle on things that really don't sit well with you. A bad agreement that is signed under pressure in mediation, it's still a binding order. So be careful of that. Now let's talk about hearings and trials. Okay, if mediation does not produce an agreement, your case goes before a judge. The judge hears your case. There is no jury, there is no jury trial, there is no jury verdict. All right. The judge is going to hear some things. They're going to hear testimony, which is oral evidence. They're going to review the evidence. They make a decision based on that information. Okay. So your hearing might be a short motion hearing, for example. Maybe there's a specific issue that a motion was filed on. Give an example, on mental health care for the children. You filed a motion for mental health care, and that gets heard. Okay. It might be a full on trial, right? Motions that have been filed, motions get heard typically before you get to the trial process. Okay. Sometimes we see that like it's all kind of combined and it's heard on one day. That's not abnormal. So don't feel like if in your jurisdiction they're doing something different, it's wrong. Not the case. I want you to know what you're walking into in court, right? Like you're walking into a complete stranger hearing your case and making a decision based off of the information that they're hearing. They don't know anything about you, they don't know anything about your ex other than what is being fed to them. So we need to really tighten up our stories. We don't have to overly focus on what happened before. The judge is not as interested in the backstory, unfortunately. But what they're interested in is like understanding how the child is impacted in all of this in custody cases. When you walk into the courtroom for a hearing or for a trial, your documentation should be doing most of the work for you. Now, if you're using the documentation kit or even like the spreadsheet, right? Which has been like my improvement of the same. If you're using that, that is not the evidence that you're going to present in court. Okay. I want you to look at the documentation spreadsheet, right? The tracker, as this is me getting all the building blocks together, right? And I'm going to start building my house with these blocks. I've got to put them all together, right? Think of it as a puzzle. When we start putting a puzzle together, some people like to start with the corners first. Some people like to start with the outsides, right? All the straight edges. You're doing the same thing. So if you just hand your tracker or all this documentation, or you go to court with a huge fucking ass binder, are you handing the judge a put together puzzle? No, you are handing them the box of all of the puzzle pieces that are not sorted, they're not put together. You might understand the story, but if a stranger on the street that has minimal education, cannot understand what's happening, you don't have your shit together. So work on, while you're documenting things, there's a lot of things that never ever make it to a courtroom. Okay. But are there certain patterns of behavior? If I've had temporary orders and my ex is not filing, not following the order, what do I want to show? How this temporary order is not working. I want to discuss how he's violating, the orders, the terms of this order, and what I've tried to do to still navigate the situation despite them not listening to what the court has ordered. Right? That really tells a compelling story. Because again, you're looking like you're not adding to the problem. We don't want to add to the problem. Now, final orders. And why does the word final not mean forever in family court? Okay. After a hearing, judge hears what was called, right? Here's the case, and they come up with a final order. It's called permanent custody order, final order of the court. Okay. The order governs your custody arrangement going forward. Now, again, when this initially happens, I want you to look up some things. Okay. I'm going to teach you how to do the research. You can go onto Google. You don't want to go to an attorney's website. You might have to go to the second page of Google. But you're going to Google how or when can I file for modification of custody? The reason I ask you to do this is because in some jurisdictions, there's actually statutes that are written that say, you have to wait 2 years before filing for a modification, unless it's an emergency. All right. What would be deemed an emergency? Is the child physically hurt? Is the child in immediate danger? If you have questions about this, let me know. and I can guide you to determine whether or not the court is going to see what you feel is an emergency as an emergency. Okay? Now, the final orders can be changed, right? You can modify custody, again, based off of whatever that deadline is. There are some states where it doesn't say anything. If there's nothing that is said in your state, I want you to wait at least 6 months, ideally 12 months or more, before you move to file for modification. Okay? The reason we wait this long, and it feels like an eternity, I know when I'm saying these words to you, but time really goes by fast. And that gives us enough time to get a solid pattern of behavior. We're not filing it the first time that they're violating the orders. That's not going to get us anywhere. In fact, oftentimes those cases are dismissed. Nothing happens. Okay. I've seen cases where there have been motions filed for contempt over and over and over again, almost on a monthly basis. Nothing has happened. Nothing has changed. Okay. That is not the proper venue to go about modifying custody, right? Now, filing contempt and modification 12 months from now, different story, right? Whole different ballgame. So, looking at what is a substantial change in circumstance? Is it good? Is it bad? It doesn't always have to be bad. Okay, there also can be good things. Let's say you were offered a job and you're going to move, and we can start with that, and then go into how this order is not in the child's best interest. That vague language that I hate, right? But why it's not. Unfortunately, dad hasn't been following the order. Why do I say dad? Well, because 90% of all of my clients are women, right? Y'all know this. Y'all are here. In the collective, I only have women. All right. So if we know that final orders are not permanent and we can build our case, we're going to go through our order before we file for modification or contempt, and we're going to go through it line by line. What does it say on page 1, section 5? Has my ex followed this? No. Okay. So make an extra copy of your order. This is what I do. Okay. This is my process. I find that it helps me and my brain. Make an extra copy of the order, go through it initially, say, nope, hasn't followed, nope, hasn't followed, nope, hasn't followed, nope, hasn't followed. Okay. Start with that first. Then, what is our documentation showing us? All right, I know that they haven't followed these things. Can I recategorize things? What is this particular area of the order that has been violated? Things can always be changed. It can always be modified. What counts as a substantial change in circumstance varies by state, but generally it includes things like relocation of a parent. Is there a significant change in the child's needs? Do they need to go into therapy and dad is stonewalling and not allowing therapy to take place? Is there a change in the parent's ability to care for the child? Those violations of the current order is a substantial change in circumstance. I don't care what your attorney says, it is a substantial change in circumstance. Okay, because the court's idea when they put the temporary order in place was that the terms be followed. Is there a change in the child's preference depending on their age? Now, in a few weeks from now, I'm going to have a podcast episode out there where I'm going to talk with a guardian ad litem who is also a parenting coordinator. And I've had conversations with her already, but ultimately talking about the roles of a gal and what you can expect from a guardian ad litem, right? People think of child's preference, I need to have a gal that's going to express this. Not always. There's other ways, right? Like if your child has a therapist, that could be helpful. Now, You guys know about my own case. I've told you time and time again, but I'm going to share it with you briefly now. Right? I started out with 50-50. It was 1 week on, 1 week off. I was with my boys. We had gone to mediation. I had filed for custody. And originally, my ex and I had a verbal agreement because, yes, I was that person. And we had agreed to a 2-2-3 schedule. Well, what happens when you avoid court and written agreements? Well, at literally the flip of a switch, they're like, nope, we're going to do something else. We're going to do 1 week on, 1 week off. Okay. So we did that. So I go to mediation after I filed for custody. He was not budging. Not budging. I'd done some research. I knew, also based off of my prior experience in family court with my daughters, that a judge was unlikely to give him anything less than 50-50 because he'd always been in the children's lives, right? He'd always been there. That was his argument. Okay. So in mediation, I agreed to 50-50, 1 week on, 1 week off. And from there, I put my game face on. Okay. There's those times where I'd given him the benefit of the doubt. He fell through. When I started really honing in on my documentation, I backtracked because there was a lot of things I hadn't written down. There was things that I hadn't, keeping track of. So I had to go back and figure it out. So I just started like by literally writing down on a legal pad what had been happening. Then I went on building this pattern. I documented for a solid 18 plus months all of the shit that had been happening. Him not showing up, him not seeing the kids, him, pawning the kids off to his new partner, to his mother, him not being available, never taking the kids to a medical appointment. My kid had like a second-degree burn on his leg, didn't do anything about it. Right. I took all of those things, but I will tell you what really got the court's attention was how my ex was not seeing the children. So over 12 months, he had missed 91 days of his parenting time, 91 overnights. That's more than half, right? 90 is kind of like the cutoff for half, 91 is more than half. So I presented that information. I also presented how I had no communication with my children during his parenting time. We had other things that were happening, right? There was a protective order in place that indicated that the children would have a device to communicate with us, with both of us on, right? At either parent's house. And the device would not travel back and forth. My kids had no contact with me. Did I ask dad about the device? You bet I did. It was in Talking Parents, right? We were ordered to communicate in Talking Parents. I looked at the communication. I gave my communication to Pattern Viewer. Pattern Viewer's analysis and report truly saved my life. And it was eye-opening to see that I was not the problem that I thought I was, right? So then I got all this together on my Pattern Viewer report and I attached it to what I was filing. And that's how I got a lot of this stuff in, as evidence. So I showed the court through evidence over time who was actually showing up for the kids, who was not, who was co-parenting and communicating effectively, and who was not, right? And to have 50-50 custody, well, we need to co-parent effectively and be able to communicate. So I chipped away at it a little bit at a time. The final order that I started with was not the order that I ended up with. Because as you know, I have sole legal and physical custody of my children. There is no mandated visitation. There is no communication with our children and their father. Okay. Now, is that success? Is that a win? Yes, right? But also, my kids have gone through a tremendous amount of therapy so that they could work through the feelings of feeling abandoned by their other parent, right? And not having that healthy relationship with the other parent. I know how much my children have benefited from therapy. They don't blame themselves for, their father's behavior. They don't blame themselves for any of those things that had happened. And they know that it's not their fault. Okay. What the long game actually looks like is going to be different for everybody. Okay. But my long game, I've given you now my timeline. I've told you what I did. Obviously, I'm giving you the Cliff Notes version. I think the most important mindset shift of everything that I've shared today is that this is the damn long game. There was times that were there things that I had lost. Yes, I lost things. I also had a lot of wins in family court, but I had significant losses too. I had a restraining order against me, right? A mutual retaliatory restraining order was filed the day after my ex was served with mine. I had that against me for a year. Did I have losses? Of course. But I had a lot of wins, and I tried to focus on those things. I was paralyzed just like you when it came to documentation, putting things together. I would sit with one of my really good friends who was coaching me. We would sit on Zoom for an hour at a time so I could go through things. We wouldn't even be talking. I would just get the work done. I would be doing the work. If I had questions, I would go to her. Family court is a long-term campaign. Campaigns are won with, think of political campaigns. They're won with strategy, patience. Do politicians love to attack their rival? Of course. But that's not what we're going to do in family court. We can attack them by presenting the evidence. High conflict people burn bright and burn out. Your goal is to outwit them and outplay them. When you feel like quitting and giving up, that's when you keep going. High conflict people are exhausting to everyone around them, including the judge, right? Like, judges don't really like to sit in and listen on these cases, but you have the opportunity to present yourself as the reasonable parent, and judges take notice of that. There's oftentimes people think that they have a really good case. They're presenting all the information possible, but they're not sounding like the reasonable person because they're focusing on their ex's behavior and know their new partner. And now their new partner is with my kids, right? Like, think about it for a second. Did that just potentially play into the narrative that your ex is spinning of how you might be obsessed with them? See, she's so controlling. She won't let me ever do things on my own, right? It does. So don't play into those narratives. What is the narrative that your ex has about you? Write it down and create a game plan in your head of, I am not going to play into this narrative. Ask friends that you trust. Hey, I was thinking of saying this in terms of my ex is not following this part of the order. This is what he says about me. Is my presentation and saying this, does this make me fall into his narrative? What do you think? Do you think that there's truth to that? Now, give me a non-biased answer. Your ex is always, almost always calm, right? In family court. Your job is to also be calm, be organized. I want you to always be child focused. Your ex and their narrative will often spend. I met with someone this morning, right? And The ex was saying she was abusive to me. She has committed serious acts of domestic violence towards me. Nothing to do with the kids. The kids were not mentioned. She's not abusing the kids. She's not hurting the kids. This is a classic case of Darvo, right? Was that child focused? No. Judges also are going to remember the parents who have been back in their courtroom 4 times in 18 months with random chaotic bullshit filings, emotional arguments. They're going to remember how you show up. So, again, it is your job to be the parent that the court looks forward to dealing with. I mean, I don't think any judge really looks forward to hearing these cases, but you're the reasonable one. You're the organized one. You're the one who only comes back when it really is important, when it really matters. You are not filing motions every time your ex is violating the order, because that's just going to get backlogged in family court. You are building your case instead. So when they're failing to show up, good, let them. They're failing to follow through, good, let them. They are not being the parent that you hoped and anticipated that they would be to your child. Let them. Let them not be that person, because they are handing you evidence for your case. The grieving, all of that happens on your own, separate from this. We are building a case on credibility. Okay, how can I present myself as a credible person and getting out of these scenarios of he said, she said? What evidence do I have to show that this is the behavior that I've been experiencing? So, wherever you are in the process right now, maybe you're at the very beginning trying to figure out, what is coming. You're in the middle, stuck with temporary orders that, not super satisfied with, wondering when this is finally going to get resolved. Maybe you're getting ready for your trial. Pretty stressful time. Maybe you now have a final order in place and it didn't exactly go the way that you wanted, but you're understanding, okay, I still have options. Hear me out. Okay, it is not over until you say that it's over. Not when your ex says that it is, not when a judge issues an order. That doesn't mean that your case is over. Not when your attorney tells you to just accept it. I've talked about it before, but your attorney works for you. You're their paycheck. If they are not doing the job that you hired them to do, you fire them, just like you would an employee, and you go on to the next. Or you wait, should I work on representing myself? I can say a lot of really good positive things about pro se litigation. I did it myself. Obviously, I was successful. I beat 6 attorneys. Remember, permanent orders are not permanent. The family court system is built to be revisited as circumstances change. Again, it's also a cottage industry, right? So they know that there's things in your order that are not going to work out. They're anticipating you to come back at some point. High conflict cases, circumstances are always changing. Your job now is to play the long game, keep documenting everything, use the tracker, use BIF in your communication. Only BIF. If you think that you're using BIF, you're like, oh, I've really stopped. Run it to make sure that it's BIF. Run it through AI. Run it by a friend. Share it with me. Post it in the collective. You are showing up as a stable parent each and every time. Are there things that maybe your ex is fighting you over? Maybe it's a school for your child to go to. You really want them to go to another school. Are there things that you can learn to let go of? Before I leave you today, I want you to remember that your ex thrives on conflict and chaos. When they're getting constantly a rise out of you, that's conflict. Don't give it to them. Are there things you can definitely let go of? Yes. I'm not going to tell you what they are because that's your life and your circumstances. And we know that there's maybe things that we're holding on to. Maybe we feel that there's some things that are not just, they're not fair. I know. But what can I let go of in order to give my ex more rope? Remind yourself every single day, Bridget started with 50-50. She did not end up there. Neither will you, no matter what your situation is right now. I want to thank you for being here today, for showing up, sticking it out till the end, and I will talk to you next time. Sending you a big hug. If today's episode resonated with you, make sure you share it with someone who needs it. You can find me on all platforms as Coach Bridget B, or at my website, breakingbadasscoaching.com. If you are ready to work more with me in a session, check out some of my guides, learn how to master your documentation, or join my exclusive community, you can do that through the link that'll be in the show notes. I want you to remember, you have survived this far. You've made it through this episode, and you continue to show up. You're going to continue to survive, and I will see you in the next episode.